So welcome everybody. We're getting close to the end of the certificate course. So I imagine some of you are feeling a little tired probably right now. A little maybe stressed about your final projects or excited about your final projects, which is awesome. Um, Today we're going to have a guest speaker talk to us a little bit about AI and Creative Commons, because this is a thing, it's an emerging technology. Things seem to be changing very quickly. So we don't really cover AI in the course itself, just because it's kind of hard to pin down exactly what's going on. You know, we write the course material months before you take it. So it's hard to keep up with all of the changes. But that's why we're really glad to be able to do this webinar with an expert. So I'm going to introduce Deanna Noory, who is the Copyright and AI Counsel here at Creative Commons, where she serves as a subject matter expert leading internal research, analysis, and strategy development, as well as public-facing communications and education. And she's dedicated to serving the good of humanity by combining her background in law, journalism, the arts, and community building, and is especially interested in the transformative power of the internet and media/entertainment law, with a major soft spot for music. Previously, as a policy analyst at Canadian Heritage, she helped draft and implement the Online News Act, and then joined the copyright policy team, where she led the music file and co-led on AI, including Canada's consultation on copyright in the age of generative AI. So Deanna holds a Juris Doctor and a double major in arts and English language and literature from Western University, and was called to the Ontario Bar in 2023 and is usually based in Montreal. So I'm going to turn things over to Deanna today, and I will just really quickly note for participants, um, please feel free to put questions in the chat as we go, or if you have comments or just, you know, some thoughts to contribute. We always love to hear those, and we will ask questions kind of as we go. If there's something that's relevant to what Deanna's speaking of, I'll probably interrupt and see if she can address it really quick. And otherwise, we'll also hopefully have time for questions at the end. So Deanna, over to you. Thank you very much.
Thank you, Shayna. So today we're going to be talking a bit about AI in the commons. There's a lot to unpack here as AI is transforming how knowledge is created, shared, and reused. People in the open movement are at a crossroad that's going to define the future of access to knowledge and shared creativity. There's a lot of different exceptions and limitations to copyright around the world that give latitude to AI training, but these laws vary significantly. So since CC licenses are copyright licenses, it follows that the application of our licenses to AI training is similarly complicated. So today I'm going to talk a bit about our latest thoughts about the relationship between AI and copyright and the existing CC licenses and legal tools, both in the US and globally. Then we'll talk about the latest developments in our CC Signals project, which is a proposed framework to help content stewards express how they want their work used in AI training, emphasizing reciprocity, recognition, and sustainability in machine reuse. So as you know, CC is a nonprofit that supports the infrastructure that makes the public commons possible in today's digital environment. And the public commons enable us to address the world's most pressing challenges and create a better future for everyone. And when CC started, we collectively faced a choice about the internet. Would it be open for the public good or closed and used to concentrate power and restrict access to knowledge? We're now at the same inflection point, but it's about AI. And AI systems are built on the commons, trained on centuries of human thought and culture. While AI technology has the potential to advance health, science, and prosperity, it also threatens the very foundation on which it depends. For the AI technology to flourish, the commons must flourish. And for the commons to flourish, creators need agency, and those who disproportionately benefit from the commons need to give back in ways that sustain it. This has
Deanna,
always been, oh,
sorry,
yes.
let me cut in for a second. We are still seeing the first slide, and I'm not sure
Oh,
if that's where we should
hang
be for
on.
some reason.
No, it should be switching. One moment, please.
It's doing the thing where it switches in your presenter window and not in ours for some reason.
Yeah, okay.
Sorry, folks, give us a second to do a little bit of tech check.
Mhm.
And if we need to, we might need to restart sharing again. I don't know.
Yeah, let's just reset the share. One
Yeah, it
second.
looks like it might have just frozen in that window for some reason.
Okay.
Sorry, folks, we did test this before you all got here, and yet
Hmm.
this is how technology works sometimes.
Yeah, this is what we mean by the transformative power of technology. It's just screen sharing. Okay, are
Okay.
the slides
So,
switching?
yes, but now I can see your speaker notes.
Hmm, that's also not what we want.
I think usually I will put it in presenter view first, and then I can pick just the one window I want when I share for Zoom.
Okay,
And that sometimes works.
interview.
There we
Okay,
go.
how's this? Slides are moving?
Yes, slides are moving,
Yay,
and now this is
awesome.
the slide I expected to see. Awesome. Thank you very much.
No
Carry on.
worries. Okay. So, with regard to these issues, copyright alone can't fix this. CC licenses alone can't fix this. Protecting the commons in the age of AI requires new legal, technical, and social approaches that protect the public interest as technology evolves and shapes culture and knowledge, ensures sharing thrives beyond copyright frameworks, challenges monopolizations of data by concentrations of power, and empowers a global movement to sustain the commons as a cornerstone of democracy. So there's a lot of questions about copyright in AI. For some reminders about copyrights, these principles apply internationally across jurisdictions, thanks to things like the Berne Convention. Copyright is automatic. It doesn't require registration or formalities to exist, although in some jurisdictions like the US, you may need to register to sue. And copyrightable materials must be original, creative, and often, quote unquote, fixed in a tangible form, though not always. So with AI, here's a very simplified description of how training an LLM works, which is a large language model, to give you an idea how copyright might come into play. So large language models like ChatGPT and Claude, Gemini, they are trained on massive data sets, many of which include copyrighted works. Training an LLM involves copying training data to learn statistical patterns between billions of words within a data set. The data is then cleaned, which could involve removing duplicates, spam, and unusable text, and then tokenized, which means converting it to numerical form, and then fed into a model to help optimize its internal parameters, which is just kind of the numerical values it adjusts while learning, the weights, so that it gets better at predicting things like the next word in a sentence. Then the model responds to new and unseen inputs, which are user prompts, what you might ask ChatGPT to generate outputs, which is what it gives back to you. So once it's trained, the model then doesn't retain the training data itself, but instead captures the abstract patterns that enable it to generate responses to these user prompts. And this trained model can later be fine-tuned on smaller task-specific data sets without needing the original training corpus, which is that training data set that it first referenced. The main questions with regards to copyrighted AI can be divided on whether copyrighted material is being used for input, which is generally referring to AI training, or whether the outputs are subject to copyright, which is the stuff that is created wholly by the machines. When we talk about inputs, we're asking things like, was the work used in a way that triggers copyright? And if so, was the use lawful? Using is defined in different ways in copyright. It could involve, sharing something on your website or maybe remixing it in a certain way. And when we ask is the use lawful, perhaps you might have a license or there's some sort of exception or limitation to copyright, like fair use that applies. The questions might also be if the training involves making copies and if copying for training even constitutes infringement. This question varies by jurisdiction, and we'll get into it a bit in the next slides. What attribution, if any, needs to be provided? The training data sets, the individual authors of content that's being used in the training. At what stage should that attribution be provided? Perhaps at the beginning or later on. The outputs are questions of infringement and authorship and copyrightability. So who is the author of a wholly AI generated work or an AI assisted one? We have some case studies to talk about this. Is human creativity a requirement of copyrightability? Most jurisdictions and policy discussions agree that the answer to this is yes. Is the AI output too derivative of the training data, or did it regurgitate it directly? And a good example of this is the New York Times and OpenAI case, where part of the New York Times complaint was that ChatGPT outputs made exact reproductions of their articles. OpenAI argued this was a bug and said the purpose of their tool is to generate new texts, not generate or reproduce training materials. And they suggested that the exact copying was facilitated by detailed prompts that would ordinarily violate their terms of service. This case is ongoing. So the biggest question about the copyrightability of outputs is that of the originality and creativity requirements. So most jurisdictions agree that solely AI generated content does not meet that threshold. And there's existing precedent, such as the monkey selfie case, that originality requires human participation and intervention. This was a case where a photographer tried to claim copyright over photos that were taken when a monkey pressed on his camera shutter. And he argued that he engineered the situation by going to Indonesia, befriending a group of these wild monkeys, and setting up his camera in a way that a selfie could be taken. So Wikimedia refused to remove the pictures from its Wikimedia Commons image library because it claimed copyright is held by a creator and a non-human creator. That is a non-legal person, because corporations can be considered legal persons, cannot claim authorship. And the court rejected the case where PETA was suing on behalf of the monkey to claim authorship, and PETA is an animal rights organization. The court ruled that animals cannot own copyright. So for practical purposes, solely AI-generated outputs are not eligible for copyright. And these things would automatically enter the public domain, though there might be some other restrictions depending on the content. But how much human is enough to make something original? There's no clear-cut answer to this. It's analogous to asking when something becomes a derivative work. Many things in copyright exist on a spectrum, and this is just another spectrum. So copying and pasting something written by somebody else wholesale without changes, that's copying, not a new work. Adapting a book into a film is a new work, what we call a derivative work in copyright, but there's a lot of gray area in between as to how much change needs to happen to call something an adaptation. So with AI, we have some examples. Um, So the Suryaast example is one of the earliest well-documented examples of this discussion. Ankit Sahni, intellectual property lawyer from India, created Suryaast by prompting a generative AI tool called Raghav to combine Vincent van Gogh's painting Starry Night with a photo he'd taken of a sunset. So his inputs were limited to taking and selecting the photo the image is based on, the style image of Starry Night, and then setting a value of the level of style transfer the tool was to use. In 2023, the US Copyright Office rejected his copyright registration, stating that whether a work is sufficiently human created is case specific, but if AI is responsible for, quote, traditional elements of authorship, the work is not copyrightable. Meanwhile, in Canada, in 2021, the Canadian Intellectual Property Office granted this work copyright protection through its automated registration process, meaning there wasn't review, and it listed Sani and the AI tool as co-authors. In July 2024, a Canadian Internet Policy and Public Interest Clinic submitted an application for an order that Suryaast was to be struck from Canada's copyright registry because there is no copyright in the image, or alternatively, to amend that registration so Sani is the sole owner. So this example was really big in the conversation about how much creativity is necessary for copyright protection, and the application in Canada is still ongoing. In January 2025, the US Copyright Office released part 2 of its report on copyright and AI copyrightability. This report went pretty deep into it, but ultimately it reaffirmed the importance of human authorship for copyright protection in the US, while also providing guidance on the conditions for copyright protection of an AI-assisted work. Ultimately, the threshold is to be determined on a case-by-case basis. So in February this year, the US Copyright Office granted copyright registration to an AI-assisted work for the first time. Kent Kiersey filed the application for a work called A Single Piece of American Cheese that he created using Invoke, which is a generative AI platform that he founded. He first had tried to do this in 2023 with a different image, and that was denied. So this time around, he got a big international law firm on deck, and his request was initially still denied in August 2024. But he used copyright precedents and showed exactly how this work was composited and composed. Um, the image was generated from an original prompt that he then refined using what he calls as the company's AI first Photoshop-esque tool. So this is a screenshot of the control panel of the tool, and he basically like had a video that was showing the first prompt and the way that he was adjusting things like the eyelashes, adding the cheese, which he says was not there before. And CC's position ultimately is that copyright should continue to require the human authorship requirement. This is important to develop new forms of new forms of transparency and provenance. We also have some recent decisions and outcomes from cases that have been pretty influential in the conversation. So Bartz versus Anthropic was a case where the a U.S. federal court found that Anthropic's use of certain legally purchased books to train its LLM was fair use, but its huge unlicensed library of pirated books was not fair use, leaving the damages to be determined. This was a group of authors that's suing Anthropic for using their works in AI training. And there's a lot of evidence within the case that's pretty interesting to read about Anthropic, talking about should we go and get these licenses? No, let's not bother. And that was one part of the decision. And then beyond that, Anthropic agreed to a preliminary $1.5 billion settlement with the authors who were alleging these works were used without permission. That amounts to about $3,000 per book covered. And this outcome could actually disadvantage smaller AI developers who might want to diversify the market beyond the kind of monopolies that run it right now. By setting such a high per book price tag, settlement effectively allows well-funded companies to absorb the cost while making compliance far harder for new entrants. We also have this case from Germany where the courts dismissed a photographer's claim that his image was unlawfully used in the Lowen dataset. This is a really big dataset that's used in training a lot of the foundation models we know today. It found that the use was qualified under the TDM exception for non-commercial scientific research in the EU. In Getty Images versus Stability AI, in the UK, the court concluded that stable diffusion models, which are image generation models, do not contain or store reproductions of the relevant works on which they were trained. That's what we were talking about earlier with regards to input of training data. There are no copies in the model, so there are no infringing copies for the purposes of secondary copyright infringement. Thomson Reuters and Ross in the US was the first kind of case in the US where the court explicitly concludes that the use of copyrighted content to train an AI wasn't covered by fair use, and these are fact specific. It granted a partial summary judgment to Thomson Reuters. And a summary judgment, I should say, is when the court wants to make a decision on some facts that it thinks are or that the party thinks are so simple that it should just be decided on now rather than wait for the full trial. So this partial summary judgment was on a particular issue, finding that Thomson Reuters headnotes and key number system were original copyrighted works and that Ross directly copied a couple thousand of them. And it rejected all of Ross's arguments, including fair use. And for context, Thomson Reuters is the company behind Westlaw, which is a major commercial legal research platform. They sell curated case law, headnotes, which are editorial case summaries, and that editorial analysis to lawyers and courts. And their key number system is a taxonomy, like kind of index of legal issues. And Ross Intelligence was a legal tech startup developing an AI-powered legal research tool intended to compete with Westlaw by answering legal queries using machine learning models. Ross Intelligence is no longer in business, but their the lawsuit, I believe, is being funded by their insurance. So the application of copyright law to AI training is similarly complex. There's no distinction. There's a distinction between our position on copyright and AI with respect to whether copyrightable material can be used to train AI in the first place versus how CC licenses might impact AI training. So perhaps the bigger question is, what about using this copyrighted or CC licensed material for AI training? And we've talked a bit about the exceptions and limitations. So if the copyright licenses don't apply, as in CC licenses, then these aren't really part of the conversation. And our current information is based on the interpretations of existing law, and new legislation could be passed at any time. There's a lot of these cases that we just discussed that are working their way through the courts, but the precedents are far from being solidified into any sort of international consensus. So we're in uncharted territory, but we can make some reasonable logical inferences based on what we already know. First, is this even allowed in terms of the use? So regardless of the tool or license or preference that may apply, our position is that ideas and facts are not copyrightable. People should be able to analyze works and use copyrightable material with it, including using machines to do that analysis. That is, AI training will generally be fair use, and that is consistent with copyright. So the flowchart is only for illustrative purposes. It's not necessary to go through it like, you know, but if you do, then you can look at it in terms of like where you're starting and then think about whether compliance is required, is the output going to be shared? And if we look over here, similar kind of analysis, training AI models usually requires making copies. If they're copyrighted, there could be implications for copyrights. We have the exceptions and limitations to think about. So it's all really case by case. Sometimes the AI models may reproduce or store certain copyrightable expressions of work on which they were trained, as opposed to simply copying the data about them. This is commonly referred to as memorization, but AI memory doesn't work the same way as humans memory, and nor does AI learn in the same way that we truly do. So there's a lot of, I think, simplification that happens in the language that we use to discuss these issues. It's very difficult right now, and in some cases impossible to determine if memorization is happening and how much. Usually people think that it's happening if the outputs are substantially similar to the original inputs, as in the New York Times case. AI developers generally try to mitigate this as much as possible. So let's say that there is copyright. We might be able to think about how some CC license conditions may apply. And this is something where, like, even if a developer maybe doesn't think that it's necessary to comply, maybe they are thinking it's a more ethical way to use and share data or whatever other reason. If you want to be really conservative about it, this is the analysis that we've come up with to minimize the risk of copyright infringement as much as possible. So the by condition, all CC licenses have this. It requires attribution to the creators of the licensed material. So for AI model training, this could entail linking to specific CC BY materials used in the training within the model card or accompanying dataset card, where retrieval augmented generation or other methods are available. And this is when you ask an LLM, for example, a question, and it comes back to you with links, it retrieves them for you. Or other methods that are similar are available, providing attribution to the CC license work tied to that particular model output with a link to the source is ideal. The share alike requirements requires that adaptations be shared under the same or compatible license. So in practice, it's not technically possible to tell if an output is an adaptation of share alike content within the training data because of how abstracted the data is at the trained model stage. However, it may apply to specific outputs when a user intentionally generates a recognizable adaptation of a particular CC share-alike work, for example, transforming a CC share-alike text or image, because in that case, the output itself is a derivative work. The non-commercial requirement means the work is only for non-commercial uses. So if the training data includes any work with non-commercial restrictions, then following that, it would need to be applied to all stages, from copying the data during training to sharing the model. All of that needs to be not for commercial gain. And the non-derivative requirement prohibits creating and sharing derivative works. So this means that it shouldn't be used as training data since it would be kind of a derivative of the work itself. So copyright alone is not enough to meet these challenges. AI systems rely on human created content at a massive scale, and openly shared works have been treated as free resources for commercial gain, concentrating power and undermining trust in the commons. CC Signals is a proposed framework that enables creators and content stewards to express how they want their work used in AI development, emphasizing reciprocity, recognition, and sustainability in machine reuse. It is a flexible, evolving framework informed by CC's principles and tested through real-world experiments and collaborations that we are currently working on. The idea is simple. There's a steward of a collection of content, such as a repository of research inputs, may apply a signal to, sorry, research outputs may apply a signal to express a set of criteria about how the content can be used by machines. That party is called the declaring party. And the signals are aimed at incentivizing actions in return for machine reuse. The development is based on our ideas that there are many legitimate purposes of machine reuse of content that must be protected, for example, research and web archiving, and an ecosystem that better addresses the concerns of those creating and stewarding human knowledge is both possible and necessary. Our goal is to restore autonomy to creators while preserving open access to knowledge. True openness means participation with fairness and respect, not unchecked extraction. So, as human content becomes data for machines, we want to build a new social contract to govern that relationship. The potential signals could look like the following: requirement for credit based on the method, means, and context of use, a direct contribution to the declaring party, which could be monetary or in-kind support. In-kind support could mean perhaps providing them with the tool you've created for free, or if you're synthesizing a bunch of their research, maybe transcribing videos, then you provide them with those transcriptions. An ecosystem contribution refers to a monetary or in-kind support back to the ecosystem more broadly of the open community and the commons. The open requirement requires the AI system must be open. There are different definitions and debates as to what it means for an AI system to be open, so that is something that is under development. And as stated here, these signals are overly simplified right now. For them to be widely used and implemented, they need to be machine readable, interoperable across different platforms, and new norms will need to be developed to help express and enforce compliance. In some cases, applying a signal may be legally enforceable in some jurisdictions and in others not. So our hope is that compliance would be expected regardless of enforceability. As it stands, this list also prioritizes standardization, so we've opted for fewer signals that represent larger buckets. And CC Signals is currently being explored through implementations and experiments, including a partnership with the Mozilla Data Collective and including the contribution signal within the really simple licensing framework. So the Mozilla Data Collective is, according to them, rebuilding the AI data ecosystem with communities at the center. They provide over 300 high-quality global data sets built by and for the community in a transparent and ethical ways. So we have dual routes into Mozilla projects. Common Voice is a CC0 public data set to help tech speak different languages, and the Data Futures Lab, which is an experimental space for instigating new approaches to data stewardship challenges. So MDC works by allowing people to share their data, retain ownership of it, and control who uses it. And then really simple licensing is an open standard that lets publishers define machine-readable licensing terms for their content, which could include attribution, pay-per-crawl when a bot is crawling on a website to collect data on there, and pay-per-inference compensation. Inferences are what a AI system does to generate its outputs. So we have the MVC offering that infrastructure to data set stewards and holders who may not have technical resources themselves to make their data available to AI developers. They would make their data set available through the MDC, and one or more CC signal could be applied as a requirement for the AI developer to ingest the data set. This would allow us to track metrics in terms of the effectiveness of CC signals implementation. And with RSL, including a CC signal, such as the contribution signal, alongside other RSL terms, allows us to test usage and compliance alongside a more commercially focused terms like pay-per-call. So the important thing here is that we're testing this contribution signal less focused on a one-on-one payment and more on the sustainability of an ecosystem. So it's an experiment in bringing that concept of reciprocity alongside some of the more true financial incentives. So there's more work to be done here. By mobilizing our global influence and community, we're also advocating for things like beyond copyright. AI investments should serve public interest research, for example, in health, climate, and education. Smaller targeted models that solve real-world problems without extractive data practices. Transparency and documentation for accountability and trust. Community-led AI governance, where those who create and maintain data help set the rules, and open source AI that supports independent research and diversifies innovation. So we're actively seeking expressions of interest for pilot adopters who have data sets they would be interested in making available for the CC signal on the Mozilla Data Collective platform. We're also interested in talking to people working in the AI ecosystem who are supportive of our efforts to protect the commons. If you're interested, or if you know someone who might be, please scan the QR code or share it and complete the form. So we have some time for questions if anyone has anything they would like to share.
Thank you so much, Deanna. We don't have any questions yet in the chat, so I invite people to add questions now, or you are welcome to unmute and share your questions and thoughts aloud. So let's take advantage of having an expert, a legal expert here who's done a bunch of work in AI and see what y'all are interested in asking about. I'm shocked. I don't know if everyone's asleep. Usually, AI is one of the things I by far get the most questions about. I'm curious, if no one else has questions, I know I do. I'm curious, Deanna, if you could talk a little bit more about kind of what we're thinking about with CC signals. So, I hear a lot of folks who CC license their work who are concerned, right? Like they CC licensed their work because they wanted to share it with people online. But as you mentioned, there's a sense that like what AI is doing is like not quite in the spirit of sharing that we had in mind 20 years ago when we made the licenses, right? Um, so I have seen a trend, for example, of people trying to use more restrictive CC licenses in a way to try to counterbalance some of those effects. I'm just curious if you have thoughts on like, I'm an educator and I just wrote a cool new OER and I want to share it, and I'm just not sure how I feel about it potentially being ingested by some large AI tool. Do you have any recommendations, things I could keep in mind? Is this something that like maybe Signals is set up to eventually address?
Yeah, well, at this stage, the signals are targeting data sets, which are bigger than just individual creators. This is a concern that I totally see as, really pressing and valid. But it is something that, like, at this stage of implementation, we haven't been able to capture just yet. Because yeah, you're right. Like, somebody might be sharing their work with this idea of education in mind, and then it's ingested by a model that perhaps doesn't operate on the same type of ethical playing field that they might support. So what preferences are just, sorry, what CC signals preferences are designed to capture is kind of right now, the bigger data sets that may contain works like that. So for example, somebody might have their work included in a data set of educational materials that they've consented to having their work included in, and then that data set steward that they trust is putting that work on the MDC as one of the examples. And then from there, that CC signal would apply. So Right now, that's where it's at. But definitely that is a big concern that creators have and that the broader community is worried about. And in terms of why we want to have these preferences there, like I mentioned, there are a lot of machine uses of data that have been happening for some time that we actually support in terms of an open internet and sharing. Like, the Internet Archive operates with crawlers. Research is done using crawlers, and um, we don't want that kind of thing to disappear. But the conversation about text and data mining broadly gets lumped into the same conversation as AI training and AI companies and big tech. But they're not always the same thing. And so we're trying to provide a bit of a distinction there. There's been conversations beyond CC signals and beyond Creative Commons where people are talking about could we maybe find a way to label different types of bots so that we know where they're coming from, and then websites could block the bots based on who it is. There's also a lot of conversations about alternative licensing practices that are more capturing the nature of AI training. So, yeah, I mean, the biggest thing that individual people can do right now is try and have some sort of machine readable preference on their webpage. That could apply in jurisdictions like the EU, where there is an opt-out requirement for non-commercial, sorry, for commercial purposes that are not like non-commercial for scientific purposes. Um, so that's the biggest thing that people can do right now, that I would share.
Awesome. Thank you so much. I'm also adding some links in the chat for folks. We talked about how we're going to be working more with like the Mozilla Data Collective and with the really simple licensing folks. And one of the things that's kind of become clearer and clearer to me over the years, you can tell me if this is like also your general vibe, is that while on the one hand, I think a lot of these issues with AI, I'm the first person who usually tells folks that a lot of these issues aren't necessarily new, right? Like we've dealt with some of these things before, right? Like in trying to figure out how original does a work need to be for it to be eligible to copyright. These are questions we asked before AI. And so there we have some things we can grasp and analogize to. That's not the right word, but you know what I mean. But at the same time, AI is moving forward on such a large and incomprehensible scale, and is ingesting so many works that there aren't going to be any easy solutions here, right? Like CC signals, we're hoping is going to be one way to help address some of the issues that we're seeing in the commons and with people sharing. But it's not going to be like a magic bullet that magically solves everybody's problems. And so we are seeing like other emerging frameworks come up. We're seeing, RSL working with some licensing standards. We've seen Cloudflare and some other places working with bots and trying to make sure that there's machine readable instructions for these things. And so I think a lot of it's going to be kind of multiple orgs working together in this broader ecosystem just to try to make this just a better and kind of nicer place to share things online. Um,
Yeah.
yeah.
I was going to say, like, I think it's a really important point. There's a lot of, different efforts that are happening across different spaces and different types of organizations. And part of what I believe is important is for us to all be able to work together on this, because, what we're up against is kind of a monolith and it's very big and very powerful. And so the collective power of people, is really important because the commons is about people. It's about community. And we want to be able to protect that, then we have to be able to band together. And I do see a question from Catherine
I
in
was
the
going to
chat.
say,
Yeah.
yeah, we do have a great question in the chat. I'll read it aloud just for folks listening in. So, something I'm a bit confused about is, what if an end user uploads a copyrighted work into something like ChatGPT and asks for a summary or something like that? I've heard some back and forth about whether this is allowable. On one hand, the system might be storing this information it didn't previously have access to, but I've also heard people say this is fine if you have your settings set so that it doesn't save the information. So, I want to upload something that I saw online into ChatGPT to get a nice summary. What are the sorts of things I need to think about if I'm doing that?
Yeah. So what you're describing here is like, the the user kind of like liability. The first thing I'll say on that is that a lot of these proprietary big AI systems, they have kind of indemnity clauses within their terms of use for the users saying, you can do whatever you want, we're going to cover it, don't worry about it. And this is just designed to encourage wide adoption of their tools. And the fallback being that they have like a bajillion dollars that they can use to cover the legal fees. And the fact that largely speaking, they've kind of been getting away with a lot of the copyright infringement they've been doing, if there is even a copyright infringement. So the difference between what you're describing is kind of like the data retention policy. So like the free services, they kind of like use the chats for model improvement. So the text you paste might be aggregated in anonymized ways unless you turn off the chat history, but it's not directly adding to the training data sets. So the model is not like memorizing what you're putting in. And it doesn't really like create a new copyright issue. So if you have legal access to the work, you can use a tool to summarize it for your own use. But if you end up like publishing that summary, then you need to make sure that it's not directly copying, that it is truly a summary. Um, so, that's kind of the distinction there. You want to make sure that the ultimate use that you get out of that output is not going to constitute infringement. There hasn't really been anything in terms of copyright claims that I know of, at least against users for the outputs of things like a summary from an LLM. But to circle back to like the use from the LLM itself, it's not so much about like the user's behavior, but the tool. So they don't necessarily store your information in the way that you would think. It's more of like a temporary storage thing to generate the response, and then it's discarded. So it's not really like the same thing technically as the work copying it and keeping it on deck in that way.
I have a follow-up question if I can. Does anything change if the work that I'm uploading is my own? Like I'm the copyright owner, and so I clearly have permission to do whatever the heck I want. Or if the work is CC licensed in any way, does that change any of the calculus here? It might not. I don't know.
Um, well, if the question is like about liability, then no, because it's your
Hmm.
work. And if you're concerned that uploading your work is going to mean that ChatGPT now has a copy of it that it can copy, the answer seems to be no there from a technical perspective. Like it's just used in that answer. Um, so yeah, and then there is another question about the if someone wants to apply a CC license
Mhm.
to something they plan to co-create with AI, what about applying a CC license to a prompt?
Yeah, good
Um,
questions.
yeah, I mean, if you're applying it to prompt, the prompt would need to be fixed in a tangible way for copyright protection. So, um, if you're just putting it into ChatGPT, then it's not really like published anywhere. It's just being used in a transient way by the system to generate that answer. And then, like, some sort of like aggregated data that comes out of it is used to improve it if you have your chat history on. Um, there's also conversations about what it means for that to be released, if ever. In the New York Times case, the court ordered ChatGPT or OpenAI rather to share, I think, some 20 million chat logs to determine whether their stuff was being used in a way that's infringing. And so, OpenAI has made this conversation about it like infringing on user privacy, et cetera, et cetera. But then there's also like claims made that it's all anonymized aggregated data. So we don't even necessarily know what that means. Um, and yes, to Shayna's point, that prompt would need to qualify for copyright protection as with anything. And then if you want to apply CC license to something you plan to co-create with AI, this, so you could go ahead and apply the license, but the question of whether that's going to be enforceable is going to depend on if the work is sufficiently original and if there's enough human involvement. So there's cases that we just discussed, and the U.S. copyrightability report. I think the report is a good place to start for anybody that wants to read a bit more about like kind of the flagship of like where that conversation is at. But it's only going to be enforceable insofar as copyright comes into play. So you can go ahead and do that and then apply the license. But then if there's some form of infringement or use that you don't support, it's gonna have to follow that, your work falls under that umbrella. Um, if ChatGPT infringes on my rights under a CC license, can that infringement be legally enforced? Um, can you describe a little bit about what you mean about ChatGPT infringing on your rights? Like, is that in terms of usage of your data and training under a CC license? Assuming that is what you meant, but that is also something where we don't have access to the data that was used. And so in these lawsuits that have come up, they found out about it in different ways. So if there's a way that you do find out that your data was used, the only real way people have been able to try and enforce their rights here has been through collectives. Like individual people just don't have the means to sue um, OpenAI, for example. And a lot of what's been happening too with these lawsuits is the people that are suing are actually like companies. The Office Alliance case is a little bit different in the sense that it was a bunch of offices that came together, but they have this like organization to support them. But like, a lot of the other lawsuits have been media companies and conglomerates that they're the copyright owned work that's created by their employees. So individual creators haven't really had much recourse, which is why when we talk about copyright not being an adequate solution to these problems, that's what it is. Like if a lawsuit is won by a big company, then the company gets the payout, but then what happens to individual creators? Um, and Catherine mentioned, so you're saying, sorry, to the recent question, if content used by the AI replicates their work without recognizing the terms of the license. So yeah, that's same as what I was describing. Like if the work ends up kind of regurgitating something that is your work and it doesn't provide attribution or it doesn't or uses or it's being used for commercial purposes. But yeah, in terms of enforcement, it's been very difficult, if not impossible, for individual creators to enforce the terms. And Catherine mentioned a recent OER session where the presenter suggested that in future OER will just be really complicated prompts written by experts that have licenses and are put into systems by students and users to generate their own version. Um, that is interesting.
Um, that's all the questions we have in the chat. I want to make space here. I'm going to do my nice awkward teacher pause and give space for other folks to unmute. If you follow-up questions or other questions for Deanna, go for it. Take the floor. I still have a question. Sorry, Deanna. I'm just going to keep using this time to pepper you with questions. Um, so I was curious. I kind of want to go back to the earlier question about co-creating something with AI, because I've been thinking about this a lot, and the way I kind of think about it and try to explain it to other people, I'd love to get a check from a lawyer and see if this makes any sense or not. Um, so if a purely like at the moment seems to be that most jurisdictions agree that something that's purely generated by AI, like solely machine generated, is not eligible for copyright, which would essentially make it part of the public domain, right?
Mhm.
So if I'm co-creating something with an AI tool, for it to be eligible for copyright in the first place, I need to make sure there's enough of my human originality and creativity in there. Um, Essentially, like what it feels like to me, and there's a lot of different versions of this, but let's say I take some text spit out by ChatGPT. Essentially, it feels like to me very similar to if I took some Shakespeare text that's in the public domain and then I significantly adapted it. And I added my own originality and my own creativity, and it was, adapted to the point where it's a new work. I now have copyright in my new work, but my copyright, a thing we often talk about in the CERT class is that like my copyright only extends to like my new contributions. Like Shakespeare's original work is still out there in the public domain.
Mhm.
My adaptation doesn't affect his copyright status. So essentially, like, and a lot of times it's kind of hard to separate out like what's from the original and what's a new thing I added. But like, let's pretend I could for a second. Maybe I like making an anthology where one chapter is solely written by AI and another chapter is entirely written by me. I can copyright that anthology as a whole and I could CC license it. But like the solely generated by AI part still stays kind of in the public domain, right? I don't know if I'm explaining this very well.
No, I get your example. And this is one of those things where the case by case analysis becomes really significant because
Yeah.
the conversations so far have really been about, stuff where it's a bit more blended together, whereas what you're
Mhm.
describing is there's elements that are purely AI generated. So I would think that what would happen is that the court or the copyright office or whoever it is would look at the collection as a whole and say, perhaps the example is like, one chapter is by me and then one chapter is by AI, but the concept is like the AI is a digital version of me as the like first person narrator of the story, right? Perhaps that could be something that's viewed as, oh, this is like a creative way of using an LLM, because the concept is that it's a bot that's speaking, whatever, right? Like, so it really depends on that. And I guess like if the example is a completely adapted version of like an output from an LLM by you, then what's helpful and what's been advised generally is to try and document each step of the creation process from
Mhm.
the original prompt up to like each refinement that you make so that if there's ever a question or a challenge of the copyrightability, then you have something you can point to and say, like in the Invoke American cheese painting thing, the guy showed like exactly how much changes were made. And the way that this is being interpreted is changing with time. A few years ago, like most cases, it was just like absolutely not. Like if it was generated by AI in any type of way, then no. But we're starting to understand a bit more about like the way that AI tools, including generators, are already intertwined in the creative process and have been used in like movies, to some controversy, to
Mhm.
do things like de-age characters or fix people's accents. But then the work overall was like original. It was just the tool was used to generate these parts, right? So yeah, it's going to be different depending on how it's used, the extent to which it's used, what proof you have that it's original. So all of these things are going to come into play.
Awesome. Yeah, I find this really interesting. And I'm sure it's also frustrating for folks that I know when I was working with faculty or with patrons that a lot of people really just wanted like a yes or no answer. Can I or can
Yeah.
I not do this thing? And unfortunately, the law isn't usually that clear. But yeah, I'm thinking about it in context of I know our participants just wrapped up Unit 4, which is where we talk a lot about the differences between a collection of things that are used unchanged versus an actual adaptation or what we
Hmm.
sometimes call a remix, where you're really blending things together in a way that they can't be separated back out. And so a lot of the times, like especially when you're working with OER, it's very similar that you have to kind of think of these things on a real case by case basis. Like, how exactly are you using the works that you're reusing? What exactly are you doing with them? What is kind of the specific details of the use? And sometimes it can be kind of tricky it's another one of those things where I think there's no bright line between like, how remixed is this thing? Sometimes there's some gray area between kind of how much um I've blended myself with the AI and kind of how separable they might be. So I just find that really interesting. Thank you very much for sharing your thoughts there. I don't see any other questions in the chat, and I know we're almost at time. So someone do feel free to interrupt me if you have any last minute burning questions. But otherwise, I think this is a great place to wrap it up. And I'll let Deanna close us out here with just these last couple of reminders.
Yeah, I mean, you already know about learning more with Creative Commons since you're here. But then the other option is to improve open licensing practices with your institution. So we do design custom trainings and workshops to meet your specific needs. So you can contact us to discuss that. And you or others can support CC by making donations. We're a nonprofit that depends on donations from supporters. And this could be just, something small or a recurring or multi-year investment in our sustainability from your institution by joining our open infrastructure circle. So thank you again. If you want to contact me to talk about anything we discussed, you can email me or schedule a call with me using the link right here. So thanks for your attention.
Awesome. Thank you so much, Deanna, for taking the time to be with us here today and talk about AI. Folks, do feel free to reach out to Deanna or me if you have any other questions or feedback. And I will also make a plug, since you are all soon to be certificate graduates, that Deanna mentioned us supporting us as a nonprofit, which, of course, we're always looking for financial support. But another really great way that you guys can support us, if you haven't joined our Zulip community yet, we're currently looking for volunteers to join that community and help serve as community moderators. So that can be another really nice opportunity to get more involved with CC and with this wonderful global community of folks we share. So if you have any interest in doing that, do let us know. And I'm also, if you bear with me for 1 second, I'm going to give you the link to sign up for Zulip if you haven't done it yet. It's another form. So yes, it's also a great place to extend these conversations after the course. So thank you all. Enjoy the rest of your day, and we'll see you around. If you have any questions as you work your way through Unit 5 and your final projects, just please reach out to me or your facilitators. So thanks, everybody.
Thank you. Bye.